having made it to this round. That having been said, I call on the Prime Minister, Mr. Michael Palmieri, to begin the round.
Thank you, Madam Speaker. Thank you, members of this panel, friends from Cornell, everyone here, Wesleyan for what's been a fantastic national so far, and Andrew Korn for some reason in the first break round we have at NATS deciding that I should give my first PM in about a year. So with that said, when they saw me, they probably were like, crap, we're going to hear something about the criminal law. But it's Yale, so we're not running the criminal law, we're running the civil law. And what we want to say is that in civil tort suits that go to trial, the loser should have to pay the legal fees. Obviously, there are certain checks on this. We're going to make sure that it's audited so that people don't abuse things and like build lots of bottles of San Pellegrino to the losing side. But that's just generally the case. This is what goes on in England. It's been proposed in the U.S. And also going with this would be a ban on lawyer contingency fee contracts.
Okay, so I have just a quick question.
Yep.
You say that you can't like build bottles of sangria to people, but assume you just assemble a very good legal defense team, as most corporations will, you're going to be willing to defend that.
I mean, within reason, like it's going to have to be subject to some sort of audit, and if like it's a
Provided that's what you would normally do.
Yes. Yeah. Okay. Yep. All right. Fine. Okay. Everyone set? Okay. 3 points that we want to talk about. The first thing that we want to talk about is that this encourages proper lawsuits. There are lots of lawsuits that get put to trial in the status quo that we feel really don't do justice to what the civil law system is supposed to be about. The first thing we want to talk about are nuisance lawsuits, right? This is where one party, particularly large companies, use types of trumped up lawsuits to scare another company into settling because the other company feels that it's going to have to pay exorbitant legal fees, right? So let's think about Microsoft and Company X, right? Microsoft tells Company X that it's going to have a civil suit against it, and it may not be the best suit, it may be of pretty low quality, right? But even if it's of low quality, there's still going to be the Company X is still going to have to spend a hell of a lot of money because it knows that Microsoft is going to get a really good team of attorneys in order to protect itself from this type of, this type of civil suit. So it incurs all of these costs on itself in getting these lawyers, and we all know how expensive lawyers are because we're all going to beat them one day. So like at that point, what we do is we prevent these suits from coming to trial because we say, first of all, this is no longer a threat, right? So Company X is no longer actually threatened by the fact that they're going to have to pay legal fees because we've simply taken that out of the system. So these things no longer clog the system because Microsoft now no longer has an incentive to use this as a threat against Company X. But the second type of suit that we want to talk about that we feel happened in the status quo but we're going to try to get rid of are low award but high quality suits, right? So let's say that there's one company that damages a lot of people, causes people a lot of harm, but causes lots of people a small amount of harm, but no one person has a strong enough incentive because they won't benefit enough to actually bring this to trial. This is a lot of what we have now with class action suits, but the problem is that class action suits take a lot of money to get going. So let's look at what happens when we have things like this. Like when companies set up, for example, factories that pollute. They typically do it in poor areas. Why? Because the poor don't have the capital necessary to get together a class action suit and to prosecute that company, or not to prosecute, but to bring the suit against that company. Because we feel that there's no necessarily profit incentive from these small value suits, and therefore class action suits aren't going to be likely to be put together, what we do is we get that out, we allow these suits to come forward because the fact that you are not going to have to pay your legal fees takes away the borrowing costs for those who would otherwise bring about these suits.
On that point?
Yeah, Berkowitz.
Good choice. Good choice. With respect to these poor people, though, isn't there an enormous disincentive to file suits because they know that if they lose and they're poor, they can't afford to lose and pay like the huge electric companies legal fees?
The incentive is that they only bring good suits. If they know that the suit's bogus, if they know that the suit's trumped up, they don't bring it in the first place. So first of all, we don't get to have them getting screwed over because they're not bringing bad suits. But second of all, we don't clog up the legal system with bad suits because people know if they bring bad suits, they're going to have to pay not only their own legal fees, not only the tort claim, but also the legal fees of the other party. The final type of suit that we discourage are suits that are bad but are high in value. Right now, people might go ahead with these suits because they realize that they have enormous rewards to get from it, right? So the mere fact that I'm going to get a lot from this suit is allowing me to take the risk. But the fact is when I'm not necessarily going to get that much because it is a bad suit, and moreover, I have to pay for my opponent's legal fees, we feel like we discourage this type of suit. Now, all of these types of suits are things we want to get rid of because we just don't think that they're proper and we don't think that they're what the civil tort system was set up to do. So the second type of thing I want to talk about, and a major point, is that we encourage proper behavior during suits. The first step in civil tort claims is this discovery stage, where you exchange information with the other party. We feel during this discovery stage, the system we set up encourages settlement and encourages settlement in two ways. First, we think that people are generally risk averse. If they have a possibility of losing, even if they bring the suit, and if they have the possibility of being financially harmed for that, I think that that's going to make them less likely to bring about these bogus suits that we talked about in the first point. But moreover, look at what happens. when this system is in place, it raises the defendant's expectation, provided that the case is good, it raises the defendant's expectation of having to pay, right? So if the defendant knows that they're going to have to pay if it's a good suit, they're going to be more likely to settle. We think that settlements are good, one, because they don't clog up the machinery of the civil court system as much, and this is a cost that we all have to pay, but also we just think that it may be a more fair and equitable and efficient way in order to settle the system. But the second thing we want to talk about under this point is that it encourages a realistic assessment of your suit. We think this is just generally good. We think that if you have this operating in the civil court system, that if you know that only proper, actually good suits are being brought, people are going to be more likely to evaluate these things and less likely to have to be influenced by things like, well, whose lawyers they have and what sort of massive legal fees they're going to have to pay. But the other thing I want to talk about here are efficient levels of care, and I want to talk about social efficiency now, and this is going to be the third thing I talk about, and social efficiency. So we feel that social efficiency is harmed in the status quo for following reasons. Look at the example I talked about before, about a company that sets up a factory in a poor neighborhood. We feel that there's a socially efficient level of care that that company needs to take. When it doesn't have to be faced with class action suits because of the financial barriers to bringing them, we feel that the companies fail to take that level of care in the status quo. Moreover, in the status quo, there is another incentive, a countervailing incentive, that the company might take too high a level of care. Like if I am constantly faced with the idea that I might be with with nuisance suits, we feel that this is also problematic because I am going to take too high a level of care in order to be economically efficient. We feel that what happens in the status quo pulls people both ways, and one's in different cases. So we never actually get people operating at the efficient level of care in order for social optimality. But now I want to talk about fairness, and this is what I'm going to close on. First of all, what is the civil court system about? It's about full compensation for harms done, right? So if I'm in the right and I'm not wrong in the suit, I should not have to pay because I was wrong. This means that the person who brings the suit, provided that the suit carries through, they are actually entitled to not having to pay for pursuing that suit. Why should I have to bear some sort of cost for the harm that was already done to me? We just feel it as injustice to injustice, and that's not a good thing at all. But the second thing, look at all of the types of things I mentioned above. Nuisance suits, bad suits, all of them. We feel like those things essentially hold the defendant hostage, and that's not something it's actually fair to do. Because we say that you shouldn't be held economically hostage by someone by a trumped up lawsuit, we think that this system encourages fairness in that sense. But finally, I want to talk about fairness to society. I've talked about how we all pay the cost for these bad suits, and insofar as we encourage settlement, and insofar as we make sure that these bad suits never actually go to trial, we're actually lowering the cost of the civil court system and lowering the cost that's passed on to all of us. So those people who are trumping up these bad suits and who are actually bringing them to trial are harming all of us, and we have a right to do something to stop them. But lastly, I want to talk about the poor. Now the poor can't sue because the poor really don't have the money necessary to bring that suit to trial. But if they know that they have a good suit, they're not going to have to worry about paying the legal fees under our system because the loser is going to have to pay those fees. So the poor are going to be more likely under our system to bring suits because they know that they are not going to have to incur the legal fees themselves even if they win. Under the current system, there are things like contingency contracts, where lawyers take a cut of what the winning party actually gets. We feel like by eliminating those on our side of the house, we prevent a system that exploits the poor and actually give them better opportunities to bring these civil suits and actually get their interests served. So for all these reasons, we propose.
Here, here. I have a speaker's response and calling leader of opposition, Mr. Robert Schwartz, to give the first opposition speech of the round.
Thank you very much. Madam Speaker, everyone who's come out here to judge, Justin Berger was fantastic today, or fantastic round, and of course Amanda White, the only one who came to prove for me. So with that said, I've got a little bit of an overview here about what they're doing on their side of the house. Because what I want to draw a distinction between, because I think it's important to draw a distinction between, is a good suit. A suit in which you had a good legal claim, in which you were actually wrong and deserve to collect damages, versus a suit that you are likely to win. Because understand that these are not exactly the same thing. A good suit, a good legal claim, involves a situation in which you are actually wrong, in which the person acted in a way which is against the law or against some kind of tort law, and in those cases you deserve to collect. Now, if a good suit were always the suit that you were likely to win, maybe you would go with their side of the house. But the fact is, that's simply not true. There are other factors which influence the likelihood of you actually winning. For example, the relative wealth of you and the person you are suing certainly plays a factor into this. The length of time that you can potentially be in trial, the kind of legal resources that you can afford. All of these things influence the likelihood of you actually winning your suit, but they don't actually influence the likelihood of the suit being a genuine suit. On their side of the house, they do deter a certain kind of lawsuit. They deter lawsuits which are necessarily unlikely to win. But what we would say on our side of the house is, it's not that you want to deter lawsuits that are unlikely to win. You want to deter lawsuits which are not grounded in a good legal claim. And that given that whenever a poor person sues a rich person, whenever there's a huge inequality in legal resources, the person is going to be unlikely to win. We think it leads to massive unfairness on their side of the house at the point at which a person who is poor, who is economically disadvantaged, simply doesn't have the ability to sue somebody else. So I want to get into this in my points, sort of the points that I'm going to bring up. And the first is that on their side of the house, nobody is going to be able to sue corporations, like very large, expensive corporations. Why? Well, because any large multinational company, or even just large domestic company, is going to have an extraordinarily large and expensive legal team. They can afford it, they have the ability to hire those expensive lawyers, and there's no reason for them not to hire expensive lawyers at the point at which any case against them could potentially set precedent, which is damaging for the company. So what's going to happen is, if I want to sue McDonald's, because McDonald's did something bad to me, say it's not spilling coffee, say it's something like paid me less than minimum wage, or like mistreated me, or did something really terrible to me, maybe they poisoned me with bad food, then I know that suing them, firstly, I'm going to be likely to lose because they have a very good legal team. But secondly, there's a double whammy, because I know that when I lose, I'm going to have to pay the legal fees that they then have. At that point, the probability of me winning times the expected value means that I'm not going to bring that suit, even in cases where I have a good claim, and I would say even in cases where I have like a 50% chance of winning, because people are, as they say, risk adverse, and are going to be unwilling to lose their house, lose their property, lose huge amounts of their financial security, to the point at which they have to pay these enormous legal fees that you're going to accrue. So given that there's an inequality in resources, and given that poor people who are suing are going to have to pay the resources of these expensive legal teams, we think it's very unfair to adopt their side of the house. No, thank you. So the sort of follow-up to this is that it doesn't just apply to corporations, it also just applies to inequalities between persons, right? If I sue Bill Gates, if I sue anyone who has access to large amounts of wealth or has a vested stake in the legal system, or even if I sue a lawyer necessarily, because you give me additional risk, because you give me sort of an additional reason not to sue, even though I have a good legal claim, we think that there are going to be good legal claims which are going to get washed out. Now this is obviously bad for like the poor people who are not able to sue. Like we already talked about why that's true. But I think it's also bad for the rest of society. Because understand that when these cases aren't set and the precedent behind them is not set, then companies are less likely to alter their practices. Rich people are less likely to alter the things that they do, which are potentially tortious, at the point at which they know that most people are not going to have the resources to sue them, most people are not going to be able to get justice in any kind of meaningful way. But the other thing, I'll take you on case, not quite right now, is that poor people aren't likely to be able to sue at all on their side of the house, regardless of who they're suing. Because on their side of the house, they're eliminating contingency law. Understand that if I'm a very poor person, I'm not likely to be able to afford any kind of upfront legal fees that a lawyer is going to require even to look at my case. At that point, when they remove contingency law, when they remove the notion of lawyers acting for free on the expectation of getting money, then I think that people are going to be a whole lot less likely to get this kind of legal representation, a whole lot less likely to get the kind of legal resources that we would say on our side of the house they really ought to have. And at that point, these people are really bad off. But the last thing I want to talk about here, before I go back to case side, is why their case sort of already exists to a certain degree. Because you can sue for like legal fees as a countersuit in a tort claim, and in those cases, the judge or the jury or whoever is evaluating the damages can choose whether it is legitimate to award them to you. We think that a case in which a judge is able to determine what kind of legal fees are reasonable and whether awarding the legal fees is going to present an enormous injustice is a far better solution than on their side of the house, where these legal fees are automatically, mechanically assigned and can actually impact the decision-making of people with legitimate cases who are going to be unable to get justice. That's bad. So with that said, I want to go back to case. The first thing they say is that companies sue to harass, and that's really bad. We don't want people to use the legal system as a mechanism of harassment. What I want to point out is that their side of the house doesn't eliminate the legal system as a mechanism of harassment. It just reserves the right of harassment to the super rich. It reserves the right of harassment to people with more resources. In fact, it also makes harassment much more effective for those people with more resources, because given that they're likely to win these kinds of cases, or potentially likely to win these frivolous cases, or even if there's a chance that they are going to lose, since the expected value of like the loss to the person who is being sued is much higher since they have to pay the legal fees as well, it actually makes harassment more effective, and it limits it to the people who already have the bulk of the power in society. Sure.
But Rob, one of the problems under the status quo is that individuals can't spend lots of money when fighting corporations. If individuals know that hiring a good legal team will let them win a case, won't individuals actually be able to spend more money when suing corporations under our side of the house, therefore beating them more frequently and getting the awards back?
Okay, that's true if you assume perfect access to money and perfect access to credit, which I think is an assumption that you can't make on your side of the house. Maybe it's true that if you hired like, if you hired like a really expensive, really powerful legal team, you could take down McDonald's. But is that really expensive, really effective legal team going to be willing to work for you, who doesn't necessarily have money, who may not be able to pay them, or are they going to want to work for McDonald's, who at the end of the day, win or lose, does have the ability to pay them? I think that they're far more likely to go than people with resources. I think that lawyers are not as altruistic as they assume. They're not willing to work for free, and oh, by the way, that's called contingency law, and they're getting rid of it. The second thing that they talk about is low award suits. They say class action suits are really, really bad, and we want to get rid of them because we don't want people just like collecting all these people and like going after people, after corporations. We think that class action suits are actually one of the few tools in our society by which a diverse group of people who aren't individually harmed a great deal have the ability to go after actors who are able to like harm a lot of people. So understand that if I'm a company, or I'm a corporation, or I'm even a person, and I do something which I know is going to harm a lot of people in a very dispersed way, there's not a lot of disincentive on their side of the house, the point at which they're getting rid of these class action lawsuits, and the point at which no one individual actor is going to be harmed enough to be willing to take up a legal claim against me, particularly at the point at which I'm going to have to pay, they're going to pay my legal fees. That's something that's going to deter. I think that's really bad. They also talk about risk aversion. It discourages bad suits. That's true. It also discourages good suits. That's not something that we want to do. They say it encourages settlements. Understand that I think it over-encourages settlements, even in cases where the settlements should not exist. Further, what I would say is that settlements are already encouraged on our side of the house at the point at which any amount of money you spend on a legal team is money that you simply don't have. So there's already an economic incentive for the parties involved to try to get out of court, to try to settle if it's good for in the best interest of both parties. On their side of the house, though, they encourage settlements when it's not in the best interest of both parties, when it's in the interest of the rich and powerful at the point at which the other person is risk averse and not willing to have to pay their legal fees. They also talk about social efficiency. They say that people are going to act with the right level of care. I think that the level of care at which people act is going to be largely determined by their financial resources, largely determined by their access to counsel and legal resources. That's not the kind of level of care you want. You want everyone to be treated equally, everyone to act with an equal amount of regard for the laws. That's what we defend, that's not what they defend. And the last thing I talk about is fairness. They say it's not fair to pay for justice. As we said before, you can countersue if you feel that it is unreasonable for you to have to have paid for justice, and the judge or the jury can choose to award it. We just don't think it should be awarded in all cases and not awarded in an unfair way. We say that it's not fair to have to pay for frivolous lawsuits. There are also things that you can do to try to mitigate that. We're not defending frivolous lawsuits on our side of the house. We just say that like allowing lawsuits to be dismissed sooner if they have no merit is probably a better solution than their side of the house, at the point at which people are just going to become risk averse to even very good cases. And the last thing they say is that society shouldn't have to pick up the tab. Again, that's true. Try to eliminate frivolous lawsuits in other ways, better ways. Don't do what they're suggesting, which just screws over the poor at the expense of the rich. For all of those reasons, I'm
Chair, Speaker, Mr. Marks, calling the member of government, Mr. Anderson, to the second government speech up there, instructing the opposition.
Thank you very much, Madam Speaker. My second MG ever in an actual round, So the overview that we hear from the leader of the opposition, I'm so used to saying member of government, is about the difference between good suits and suits that are likely to win. But I want to talk about the factors that he cites that differentiates between good suits and suits that are likely to win. He talks about relative wealth. He talks about resources. He doesn't say that like judges and juries are really, really bad and really, really random and like flip coins when they make decisions. Those are exactly the type of things that we're correcting for. Under the status quo, there is a difference between good suits and suits that are likely to win. Suits that are likely to win include nuisance suits. Suits that are likely to win include suits where massive corporation X spends millions upon millions of dollars. I'll deal with this when I talk about that first point. Spends millions and millions of dollars, and person X can't afford to spend that much money, and so that massive difference in legal fees actually allows the corporation to win. Those are the differences under the status quo between good suits and suits that are likely to win. Our mechanism is exactly what corrects for that difference. That difference between good suits and the suits that are likely to win, by addressing, in all the ways I'm about to talk about, this inequity in relative wealth, this inequity in resources. In essence, what our system does is make everyone honestly evaluate their suit. Because legal costs are a cost that must be incurred by society, by the civil justice system. The problem is a lot of people don't fully account for their legal costs and the legal costs of others when making decisions, and that's the problem. So Rob's first point was about how you can't sue large corporations. And this is the entire problem. So I'm going to spend a bit of time on this. He talks about how sort of large corporations are going to have large and expensive legal teams, and you're going to be likely to lose, so you can't sue. The first thing I'll say is I don't think this situation is any better under the status quo, right? Like, I don't think there's this rash of poor people suing rich corporations under the status quo. So I'm not sure what harm this Rob actually proves, other than there's sort of like, our system is no better. But okay, so that's all he's really proven, even if you believe his entire point. But I think one of the problems, one of the impacts that he doesn't realize is that there are two of them. One, if you have a very excellent suit, you actually have an ability under our side of the house in order to spend more, because if you win the case, that's going to be covered by the other person. So under the status quo, every dollar that poor person X spends comes out of their pocket either way. If they lose, it comes out of their pocket. If they win, it's subtracted from their reward when they're actually calculating how much they gain for the suit. Under our side of the house, since big corporation X is going to pay that, I can spend money in an attempt to actually win the suit. And if I have a high quality claim, then I am going to be able to spend that amount of money, actually match the legal fees of large corporation X, and have the case evaluated on its merits, on which it will lose. Here's the thing. We admit on our side of the house that this would be really, really bad for bad suits, but that's exactly our point. We don't want people to bring bad suits. That's one of our motivations. Because an efficient legal system that only allows not right now, Rob, that only allows for efficient expenditures. But here's another very important impact. I think when corporations realize what is going on, when corporations realize that their desire to spend massive amounts of money in particular cases will merely be, or there's a high probability of being matched by their opponents in those legal cases, then the corporations actually have an incentive to just sort of like lay low and just keep it down and make everyone better off in the end. And that's actually the incentive that we want to promote, right? As long as you achieve the ends of justice, like spending money on lawyers is a waste, right? Like economically speaking, it's just like this utile, you can better spend the money on everything else. We'd rather not have the time of everyone being used arguing in court and just spend less money to get the same outcome. And also, lawyers are terrible people, so like, I'm going to become a lawyer, no one be offended. So what we say is if you can solve cases with less money being spent, that's obviously better. Because our side of the house actually threatens corporations with viable oppositions when they're in cases, these corporations have a massive incentive to spend very little money on cases, keep the case out of the headline, keep it very down low, lose the case because they're going to lose it no matter what, but lose the case without have to pay the millions of dollars that the other person can spend. So that's why everything Rob talks about is wrong. When I ask Rob and POI about this point, the response we get is about access to credit. And that sort of deals a bit about the second point of contingency law. So I'm just going to Rob's second independent point of contingency law. So I'm just going to put it there. I think Rob describes a system, right, where like he talks about upfront costs. Now poor people can't pay upfront costs. The legal system evolves to the rules in which it operates, and lawyers evolve to the system in which they operate. One of the reasons in which lawyers can charge upfront costs is because there are contingency lawyers that exist, and those poor people go to those contingency lawyers, and so lawyers separate themselves. There are lawyers who operate on contingency a lot, and that's the market they play to, and there are lawyers who play to other market, namely the people who won't operate on contingency. Those tend to be richer people, and they can sort of charge upfront costs for those people. Here's the problem. Under our side of the house, right, without contingency fees, there are still these excellent suits out there, right? Like lawyers like being part of good suits, lawyers like taking suits, especially poor people now have an incentive to spend more money. So lawyers, just as they've adapted to the system of contingency fees, will adapt to this new system, therefore giving people access to credit. I'll talk about the other problems with contingency law after I talk to Justin.
But Andrew, it sounds to me like what you're doing is replacing good lawyers and maybe good contingency lawyers who have the opportunity for high personal gains because they take a cut of it with good lawyers and bad lawyers who work for poor people because they can't charge higher upfront costs to richer clients.
Okay.
As Mikey whispers me now.
No. The issue is, right, that if you have trust me, I'm not looking at Mike on this one. What the issue is, right, if you have a high-quality case, a high-quality lawyer is going to be able to take that case because there isn't this massive difference, right? The amount of money that I, as a litigant, have no longer matters. What matters is the pockets of the other company because the other company is who's going to be compensating you. So that's an incentive that lawyers face, not purely this incentive based on the individual who's actually bringing the suit with them. I think there is a massive problem with contingency fees, because contingency fee lawyers do tend to be worse lawyers than other lawyers. So that problem also exists under the status quo. Again, they're not solving anything. I also just find the system of contingency law to be very exploitative, right? Like, poor people are often coerced to sign huge contingency fee percentage contracts, therefore not enabling them to get a large cut of their money. That's a massive problem. Under our side of the house, we eliminate that incentive and actually give poor people access to law, right? In some sense, those things are very exploitative of them. The third thing Rob talks about is that people can sue for legal fees. And this is just wrong, but even if he is wrong, I was like, it's clearly not used enough in society. It's not used frequently at all in society. And also I'd argue that the setting of default is very important in the legal system. What is important in the legal system? It's consistency. Why is that? Because when the legal system is consistent, everyone knows what incentives they face and can make proper decisions based on that. Randomness is terrible in the legal system. They are advocating randomness where judges decide willy-nilly whether to award things by setting defaults, not right now, by setting defaults, we solve for that. The other problem is, I think actually what he's referring to is that you can oftentimes recover like reasonable filing costs and stuff like that when you actually sue. Getting awarded sort of like money for the full legal cost that you spend on lawyers is very, very rare. It never happens in the civil justice system in the United States, so Rob just doesn't know what he's talking about. Going back quickly to case because there's not much there. The first thing we talk about is proper suits. We talk about nuisance suits. Rob's only response is, again, talking about this rich poor distinction and access to credit. I've dealt with both of those already. The next thing he says in talking about class actions is he accuses us of saying that class action suits suck. We didn't say that class action suits suck. We said that class action suits are typically not used by poor people because you still need a lot of organizational money to get class action suits going. We give these poor people with diffuse harms an ability to, on their own, without having to spend the organizational costs, actually bring suit. We're fine maintaining class action suits, but we also provide an alternative. Rob never deals with the fact that we also discourage suits that are bad but are high in value, right? Something Mikey talks about at the end of this first point. If I have a suit that may not be that good, but it's worth lots and lots of money, I'm incentivized to bring it, because although I'm not going to win that much, if I win, holy crap, do I cash out. We actually discourage that by increasing the cost of bringing that suit, not right now, Rob, by increasing the cost of bringing that suit, thereby sort of discouraging those people from bringing the cost of those suits, unclogging the legal system. Second, Mikey talked about behavior during suits. Rob said that we encourage settlement sort of in the interest of both parties, and he talks about equal regard for law. I don't really understand how this is a response. Rob, so why do we tell you that we have better settlement? We talk about risk aversion, something which Rob never deals with. What the system we're talking about does is it increases the difference between my expected outcomes, right? Under one outcome, I lose my own legal fees and their legal fees. Under the other outcome, I gain the award amount and my legal fees, right? So by increasing the difference between the outcomes, it increases risk aversion, therefore increasing the ability of people to come together. That's one way in which we encourage settlement. Rob, in response to the efficient level of care point, says, we don't care about efficient level of care, we care about equal regard for law. The point of the civil system, and I'll close right here, is to bring efficiency, right? That is why we have the civil justice system, to encourage companies and people to take proper incentives and to allow people to be redressed for their grievances. We allow people to do that by allowing poor people to bring suits and actually encourage efficient outcomes and efficient level of care, something that Rob never addresses because he just misses the point.
I thank the speaker for his remarks and call the member of opposition, Mr. Justin Berkowitz. 52nd Honorable Speaker of the Round, Mr.
It's an overview, and I think that there's like, first my bigger overview is, Yale guys, these arguments are terrible. I know you're supporting your team, like don't bank them. These arguments they suck. All the ones here, one. Anyway, the actual argumentative overview is very simple, which is for them to win. I think the burden for them to show you is that in terms of risk aversion, in terms of what people are risk averse, which parties are risk averse. Corporations are more risk averse than the average person who has a lot more to lose by losing a lawsuit. I don't think they've met that burden. I don't think they've approached that burden. I don't think any of their arguments deal with that. Because a lot of what they talk about is, and Corn says this at the end of his speech, and it sort of like makes me think he's a real economist, is we want courts to be efficient, we want to encourage settlements, we want to lighten the load, but we also want to get rid of these terrible court suits against corporations. It almost sounds like I'm debating against Dick Cheney. Because from my perspective, I don't want to discourage suits against big corporations. We want bigger checks on them, but we also, in considering which group we want to make more risk averse, or which group we want to make more, kind of afraid, it's not to give corporations an enormous leg up. I don't think they've shown you in any way, shape, or form, don't even think about rather than it's not going to get taken. What? You thought? Oh, you don't think before you act. Sit down. Worth a shot. No, it wasn't. And I don't think that they've shown that. So with this in mind, let's go to Rob's arguments. And the first one he says is, and this is a bit of an overview, is a good suit isn't necessarily a winnable suit. First of all, Corn responds to this in part by saying this isn't true, and then acknowledges it much later throughout his speech, like the high value, low award, the good suits and bad suits, all those arguments on the case. So first, I think this is just like flatly true. I think this deals with nuisance suits, but there are also all sorts of institutional and structural factors that can affect how suits go about, whether or not they're good. Things like evidence and disclosure, or unpopular issues, or not, just like not, like if you've ever voted against someone in a debate round because you didn't like them, consider that juries often do the same thing. Brooks is a nice person, she wouldn't do that. But think of the unscrupulous people who might serve on juries. I think that is a good example. But also like imperfect juries, all sorts of nullification things. I think there are a plethora of examples of particularly good lawsuits in good legal grounding, but that aren't likely to win. And I think those get very much discouraged at the point where you could sue a company, you could sue another person, but because you feel that you're going to lose, you have a reason not to sue them. So I think that's the biggest problem with it. So the second argument that Rob makes is, and specifically he gets into corporations, and the third argument deals with rich people. And this is a two-faceted argument which they don't really respond to adequately. Why is this the case? Well, first he says, in terms of corporations, you wind up losing, right? Like, it just becomes very difficult to sue them, but there's this enormous aversion to suing big corporations because their legal fees, first of all, they're probably going to win because they can spend more, but also their legal fees are just colossal. And at the point where you could have to pay their enormous legal fees, this is a real problem for you. So it's a double whammy that you both lose your lawsuit, that there's both an aversion to filing lawsuits that might be good but not likely winnable, or you just don't want to take the chance of losing to them and having to pay, but also if you lose, you do have to pay. So what are the responses we get? First of all, they're like, there's not much suit of corporations now. That is like not true. I think corporations get sued all the time. I think this is an absurd assertion for quarantine. But also, and I think that there is some back and forth here in terms of them just asserting their side and us just asserting our side. So weigh the two against each other. What they're telling you is, we might encourage some suits against corporations, which might be a good thing. On our side, we're saying you very much discourage suits against corporations. I think if anything, you should side not with corporations, but with individual actors, because corporations are more likely to be able to bear the costs of losing an unfair lawsuit than an individual would be. So I think weighing simply our assertions against one another, we come out on top. But the other thing that we say is contingency provides a very effective mechanism for dealing with this. They don't explain why contingency is bad, except that it's occasionally unfair. So at that point, when you take away contingency, I think whatever lawsuits do exist against corporations now go right out the window, and that's a problem for them. Sure.
Okay, I don't understand your weighing mechanism, because your weighing mechanism assumes that we're favoring corporations and you're favoring other people. Our entire point is that you actually discourage corporations from spending excessive legal fees. You actually allow people to spend legal fees because they're going to get compensated for it.
Right. I know that. I know. I just did. You didn't understand it. Let me make it very clear. Both sides are asserting things. I think it's very difficult to engage in some sort of clash on the analysis with this because they are very much asserting that just there's going to be less of one kind of lawsuit. We're saying that there's more. I'm saying weigh the potential outcomes of them against each other. We think it's far more likely that you're going to be hurting individual people than corporations. So that's the weighing mechanism that goes on there. All right. But the other thing is, and I think Korn makes a big mistake here, is when he says, look, if you have an excellent suit, it lets you spend more. An excellent suit, not in terms of being winnable, or not in terms of being fair, but a suit that's winnable. In fact, if you know you're going to win, you have an incentive to drive up the costs as much as possible. But it's not just if you know you're going to win, it's if you want to discourage lawsuits against you. I mean, imagine if McDonald's goes to a meeting with like an individual suing them, and McDonald's is like, by the way, we want you to know, before you consider pressing forward with this lawsuit, we've spent $30 million so far. What person in their right mind would consider going on with this? Even if there's a 1% chance of you losing, you can't bear the costs of $30 million. So the only types of lawsuits are the ones where there are 100% chance of winning. I believe those lawsuits are going to happen no matter what. They don't get discouraged now, because if you have a 100% chance of winning, you can get a contingency lawyer and one that's going to treat you fairly because your case is so tight, because it is so solid. So I think at that point, given the fact that there's like, even if there's like a 0.5% chance of losing, people are very much risk averse, and that's not what we want to discourage. Rob also talks about contingency suits in general, the fact that you won't get suits or that poor people won't be able to file suits. We'd also mention that it becomes very difficult to get any lawyer to take a very hard-to-win case, even if the prospective winnings are high. Like right now, if you have a difficult-to-win case, you can probably find some lawyer that's willing to take the chance on a contingency fee because the potential gains might be like really substantial if you win. But on our side, no one takes a hard-to-win case because they know that it becomes very difficult for them to make money, because they also know that you're not as likely to go forward with the prosecution and be able to pay them in any case because they are so much more often settled. The final thing that Rob talks about is this argument with countersuits. I think this is a very good argument. Korn's like, wait a minute, I go to Yale. I apparently know con law and all sorts of like other weird law. There's no such thing as countersuits. Of course you can't sue or recover your legal fees. This is absurd. Right? It's like a tort. Like you can sue someone for taking money away from you that you had to spend on your legal fees. He even acknowledges that a great deal of this is recoverable in terms of your filing costs and other things along these lines. But the other thing is, and I think this is where he really shoots himself in the foot on this argument, is he says, look, the legal system needs to have a default measure. It needs to have consistency. Why is this a relevant argument? Why is this particularly bad for Korn to make? Because by saying that you need a default system of payment, that you can't allow judges to determine what appropriate damages should be, because there has to be just some automatic punishment in terms of the amount of legal fees, he acknowledges that judges are, by their very nature, random. He acknowledges that there are many cases where even a good lawsuit can lose because judges are random. So in arguing that consistency is important, he belies his own argumentation. No, thank you, sirs. He belies his own argumentation, which is a particular problem for them. With this in mind, let's go back to their case. So the first argument that they make is it discourages frivolous lawsuits, and they're right. I think the sort of general theme here, and like it might be right, like there's no question about that, but it also discourages very good lawsuits. And I think the general question that I would ask is, what type of society do we want to live in? I think we want to live in one which is maybe allowing some more frivolous lawsuits, but because we get a much bigger benefit of keeping corporations and very wealthy individuals in check, not giving them a very big free rein. I err on the side of more caution, of more checks than fewer checks, which seems to be what their system winds up advocating for. They talk about bad, high-value suits. Again, this acknowledges that many suits that are winnable are not necessarily good or grounded in a good legal foundation. But we also think that it very much discourages good suits that are low in value because you have less of a possibility of getting a good lawyer, but an enormous expectation of potential losses. But the other thing that they talk about is proper behavior during suits and social efficacy, and I want to talk about this class action. This is the last argument I'm going to settle on here. In terms of class action suits, particularly big suits where you're suing like an enormous corporation, the corporation's not particularly worried about this. Why? Because if they lose a $30 million suit, your $500,000 or $100,000 in legal costs is a drop in the bucket for them. On these enormous suits with enormous amounts of value, there's no added deterrent to corporations to losing if they have to pay your legal fees. Because quite honestly, it's a fraction of what they're going to lose in the suit. On the other hand, I think it works exactly in the reverse for individuals who are suing because they have to pay the corporation's enormous legal fees in addition to their own. They're not as well able to absorb the costs. Is it Madam Speaker and members of the panel, you propose.
Thank you, Speaker, so much. We call the Speaker of Opposition to be first about to each other around, reminding you that the examples are great for you arguments are really, really bad.
All right. Thank you very much, Madam Speaker. Everyone in this panel, everyone in this House, only 3 of which now will be begging for me. With that said, I've got 3 things I want to talk about. I don't think this is going to take very long because at the end of the day, this is a very simple case. So the first question I'm going to ask is, what will a poor person do on both sides of the house? Because let's assume that you've got a poor person, and you've got a good case, but it's against either a large corporation or a person with just more resources than they have. Now, they don't have the cash to hire F. Lee Bailey, but let's just assume for a second that they could. If they hire a lawyer, they might win some money. If they lose, they can lose huge amounts of money. Now, Corn says on his side of the house that it's always worth the risk. They're always going to have the credit to even try this attempt, but also that it's always going to be in their best interest to try to do so. So he talks about these like high payout, low probability suits, which are a good sort of return, have a good expected value. But when he talks about high payout, low probability suits, he ignores the possibility of low payout, but very good high probability suits, right? A suit where maybe you have a 75% chance of winning $50,000 because they really screwed you over really badly. But if you lose $1 million because that's the cost of their legal fees. No one in their right mind would take that suit, Madam Speaker. No one in their right mind would take that risk at the point at which, even if they have a good chance of winning, even if they have a legitimate legal claim that the expected value is negative, their expectation is to lose huge amounts of money, and the corporation also knows this and can spend even more money to try to deter it. So at that point, Mr. Speaker, Madam Speaker, down in this panel, what we tell you is that people with the least resources are the most risk adverse. Why? Because they can't absorb the cost of any kind of danger. They can't absorb the payout of any kind of risk. So at that point, these people, since they are more risk adverse, are going to be less likely to sue even if they do have good suits. And oh, by the way, they acknowledge that there's a difference between a good suit and one which has a high probability of winning. But they also really undercut their case when they tell you that judges and juries are a coin flip. If judges and juries are a coin flip, and you can never know, even with a really good suit, whether you're going to win, that means firstly, people aren't going to take the risk if there's a high payout in the case that they lose. But secondly, that lawyers are not going to be willing to keep their case at the point at which there is a good chance they're going to lose, and they're not going to make that money back. So at that point, I think they undercut a lot in their case. Poor people are simply not going to sue even when they have legitimate grievances, and you get all the social harms of people with large amounts of money being able to do essentially whatever they want, so long as they don't do it to anyone with more money than them. That's bad, that's unfair, that's unjust, and it cuts against the very premise of the civil justice system, which is that everyone is equal under the law, and if you harm someone, you have to pay them back for it. The second question I'm going to ask you is, what is a corporation or a wealthy actor going to do? They know that the more money they spend, firstly, the more likely they are to win because they can hire better and more legal counsel. And secondly, the more likely that the other person is going to settle out of fear of having to pay the cost, which means that you encourage huge amounts of proliferation on their side of the house. You encourage spending enormous amounts of money on these legal fees because the corporations, the less risk-averse actor, is able to absorb those fees, but they know the other person is not going to be able to, and the unlikely that they lose. You lead to intimidation, coerced settlements, settlements which aren't in the interest of both parties, are interested in the more wealthy party, and that's really bad. The last thing that I want to talk about here is a better way. What we tell you is that if the suit was frivolous, if the suit was abusive, then countersue for the legal claim. We tell you that that's something which can be done. Like they say that it's not true now, well, it should be true. I'm pretty sure that it's true. I've certainly seen people trying to countersue for legal damages, so I'm assuming that like at least some of the time that they win. So the real question in this round is not, do you countersue for damages in case of a frivolous case? The question is, do you allow it in all cases? And if you have to choose, Madam Speaker, members of the panel, of allowing a countersuit for these legal fees in the cases of frivolous cases as determined by a judge, as determined by a jury who can evaluate these things, or in all cases, such that you create these terrible incentives that they talk about on their side of the house, I think you have to go with us. Our side is more fair, our side is more just, it leads to a better society, and for all of these reasons, we are very, very proud of it.
Thank you, Madam Speaker. Thank you, everyone. Aside from the new countersuit point that Rob snuck in right there at the end of LOR, I'll deal with Justin's new point as I get through them in my points of crystallization. I'll tell you as I go. The first thing I want to talk about is this burden that Justin tries to place on us. We have to prove that corporations are more risk-averse than people. I don't even see why we need to prove that they're more risk-averse than people. I think we just need to say that both parties should be equally risk-averse. The only way that they're going to try to pull that off is to say that the poor relatively have more to lose. But our entire case is that under our system, the poor don't have relatively more to lose, and that they're only likely to have good suits, which makes them actually less likely to lose. I don't understand why this system or why this burden applies at all. We reject it on the face. So the first thing I want to talk about now is this recovery of legal fees, where Justin accuses us of legal inconsistency, right? First of all, he says that these filing costs are equivalent to legal fees. Andrew tells you in MG that they're nothing like legal fees. Filing costs are very minimal. They're nothing like the enormous amounts that can be spent on lawyers. They're just totally different. Don't try to let them conflate it. But then they talk about inconsistency, and this is where they really drop the ball. They say that we're going to allow judges to flip-flop on things like this. But they're talking about flip-flopping as to the outcome of civil suits, which is nothing like anything what we said. What we said is where judges flip-flop are when they award compensation for legal fees. It's like judges don't flip-flop when they award actual compensation, or when they award like guilt or innocence in a criminal trial. But where they do flip-flop are in things like sentencing or things like reimbursement of legal fees. We think that, first of all, we have a reason to trust judges because they don't make bad decisions or they're not inconsistent when determining guilt, innocence, or whether or not someone is negligent. But we shouldn't trust them in determining like when we're going to allow people to recoup their legal fees because we've seen in the past that they do this very inconsistently. We think that that inconsistency presents a problem because that doesn't allow people to act efficiently, that doesn't allow people to make correct decisions because they don't know when the hell they're going to get their legal fees actually reimbursed. They drop the ball on this point entirely by conflating inconsistency when reimbursing legal fees and inconsistency with actually deciding the trial. We think if the trial is good, if the case is good, the judge is going to decide it correctly. I expected that from them. I'm sorry. So I think this entire round that comes down to their idea of this is the poor versus the corporation. But that was never our case. Our case didn't restrict this thing to corporations. We talked a lot about low award, high quality suits that they just never deal with. What about things that aren't brought against corporations? Insofar as they're trying to pigeonhole this round entirely into the poor versus corporation, we're missing large swaths of our suit. But let's deal with the poor versus corporation. At best, they prove, and they never deal with this because they never evaluate anything relative to the status quo, at best they prove that our case is as good as the status quo. But I think we're going to show you throughout the rest of this point, which is the main point, why it's better than the status quo. So they say, well, this is Justin's new point now, that because McDonald's now has these $30 to $50, $100 million legal fees, they're going to intimidate the poor into not bringing the case at all. First of all, I think a lot of the stuff we talked about at the beginning of the case about being reasonable rules out these ridiculously exorbitant figures. But even if you want to say, fine, that there are high legal fees, now under our side of the house, when the poor can also get good lawyers who are no longer intimidated by these good lawyers that the corporations have, the poor no longer face this disincentive because when they have good suits, they know that they're not going to have to pay those costs, but McDonald's are going to have to pay those costs. They don't really give us a good mechanism, and we've given you a very good common sense mechanism throughout this round. When the poor no longer have to pay the legal costs that they incur, they are going to be more likely to bring up good suits because now they don't face the financial barrier to bringing those suits. Moreover, when they're not going to be encouraged to bring the bad suits, the type of suits that we want to try to eliminate on our side of the house, because that's when they face the disincentive. I think we actually win this point by a landslide because of that. But moreover, let's look at this in comparison to the status quo, right? Yeah, people might be intimidated even on our side of the house by these corporations having really good lawyers, but that doesn't make it any different from the status quo. They're really intimidated by these corporations having good lawyers on the status quo, but when under our system, they're far less intimidated because they have a chance of having their legal fees recouped. Now let's talk about class action suits. Justin's new point is that when you're being faced with a $500 million suit as it is, like a $300,000 legal cost is a drop in the bucket, the corporations can absorb this cost, right? But the whole point of our side of the house is that now when the poor bring out these suits, because they don't have to internalize the cost of legal fees, they can spend more on legal fees, so these fees become more significant. So corporations are faced with far larger legal fees that they're going to have to deal with, so this doesn't become a drop in the bucket. The poor and people who are organizing class action suits can bring far more economically potent suits against the corporation. Moreover, they never deal with our point at all that in the status quo there are organizational costs faced by the poor when they're trying to organize class action suits that we solve for on our side of the house by getting rid of a lot of those organizational costs by saying they're going to have to be paid for by the corporation, rather than on their side of the house where people who want to bring about class action suits who can't and don't have the financial means to pay these organizational costs are just screwed. So finally, social costs. I think we all agree on both sides of the house that the legal system is a transactional cost, and if we can incentivize people settling claims, this is a good thing to do so. I think we've shown you because now corporations realize that they're going to face more serious challenges when they're good suits, they're going to be more likely to settle claims, this is going to save everybody on legal fees, and this is a good thing. Moreover, we talk about efficient levels of care and how the civil court is supposed to do this. This goes entirely untouched. Rod just talks about fair respect for law. No, that's not what this is about at all. We feel that we have to encourage corporations to take the proper respect of care, and we do that when we encourage good suits against them, which is not something they get on their side of the house. Because they burden the system with all of these nuisance suits we've talked about throughout the round. Finally, we feel that the current system is exploitive of the poor because of the contingency fees that allow it to take place. The only way the poor can get access to legal help right now, first of all, is bad legal help, and second, it takes a large chunk of what the poor actually deserve. By getting rid of that on our side of the house, we do greater justice for the poor, we do greater justice for society, and we preserve the